Ms. Regenold.
May it please the court, counsel. I am Rachel Regenold of the Appellate Defender Office on behalf of Demetrius Tompkins. Mr. Tompkins did not have the opportunity for effective cross-examination of the victim in this case, so defense counsel rendered ineffective assistance for failing to object under the Confrontation Clause. The Sixth Amendment requires the declarant be present at trial to defend or explain her statement, or if she's unavailable, that the defendant had a prior opportunity to cross-examine. There's no dispute in this case that the victim was available to testify, but the state's presentation of the case prevented the defendant from confronting the accusation by the victim.
Why didn't you just call her as a witness?
Your Honor, because that would have turned our legal system on its head, because the state bears the burden, and for the defendant to be required not only to elicit the statements against him, but then to try to refute them, would flip the burden.
We had an opportunity, but at a price. Is that your argument?
No, Your Honor, I don't believe he did have the opportunity, because again, that would require him to put the burden on himself. I think had the state presented its case differently, he would have had an opportunity. But because the state presented it in the manner it did, by calling the victim first, only questioning about the domestic relationship, which was not disputed, and then choosing to call the officer and bring the accusation in that way at a time when the reliability of that accusation could not be tested. That is what prevented the opportunity for cross-examination at this point.
But counsel, shouldn't we be concerned on that particular point about the fact that it was your client's motion in limine that precluded the state from asking her those questions, you know, the whole Chursek problem?
I don't think actually, in a reading of the record, that was what prevented. The court's ruling would have prevented it, but my reading of the record is that the state intended to proceed this way anyway, that its intent was to only present her on the domestic relationship issue, but it did concede, this is your ruling, I disagree with it, but I'll abide by it. So yes, that did prevent the state from calling her for that purpose, but it did not prevent the state from calling the officer first. And then once the accusation has been brought through the officer, if it played out the same way it did without a Confrontation Clause objection, obviously, then at that point, when the victim takes the stand, there is a fact and issue.
But you don't get to pick when the state puts on its evidence and when they call these witnesses. In response to Justice Hecht's question about, you got what you asked for. You said you don't want her to testify through Chursek because now she's recanted, so we don't want her to testify to that, and the state simply says, okay, we won't call her to do that. We'll get it in some other way. They don't say this, but the obvious way to look at that is, okay, we'll get it in some other way through the police officer. So wasn't that simply a strategy of counsel to see if she could keep it all out? And she almost did. She almost was able to keep it out, and it took 3 opportunities to lay a foundation before the court let the police officer actually testify to this. But wasn't that just a strategy on the part of the defense counsel here? And she actually got what she wanted with the motion in limine.
First, I want to be clear, Your Honor, that I'm not saying that we get to dictate how the state puts on its case. I'm not trying to say that at all. That's certainly their prerogative. But I do think they have to present their case so that the defendant has the opportunity to confront the accusations at trial. And I think, yes, counsel did argue this shouldn't come in under Chursek, and that is what happened. But I don't think it was strategy to then allow this accusation to go untested, which is what happened here. Because yes, counsel made an excited utterance objection, which is a valid objection, but it's a loser, quite frankly. And because excited utterance is such a broad exception, it allows in a lot, and this clearly fell under that. And this was the most thorough foundation and ruling on excited utterance that I've ever seen. So I don't think it was strategy on counsel's part to allow the one challenged element, the one disputed element in this case, to go untested. Because you can't test it through the officer. You're testing the officer's memory. You're not testing the accuser's memory.
And then there was further testimony, I guess, of another unnamed bystander. Now, correct me if I'm wrong, but that issue wasn't subject to the motion in limine.
Correct.
Okay, so you don't have the arguable procedural problem. What's your view on that second hearsay of an unidentified person?
My argument is that that as well should have been objected to under the Confrontation Clause because this was testimonial. It was a statement by a witness regarding what that person had observed, and that it should have been objected to because, once again, that couldn't be tested. That person was not there to testify in court to their observations, and I understand the officer claimed this person wasn't credible, but that determination is for the jury. So this information also shouldn't have come in. I mean, really, the state got a bargain here because they got four witnesses for the price of one. Through Jurgensen, they get his testimony about his observations. They get the victim's statements. They get the bystander's statements, and they get the substance of the 911 call, all through one witness, and all relatively unchallenged.
Suppose a bystander should not have come in on Confrontation Clause grounds, but the rest of it does come in. Where does that leave you?
So saying that this court rules that the rest of that was okay,
Yes.
but the bystander was not okay. I think as long as the accuser's statement remains unchallenged, then you still have a conviction. I don't think just the statement of that one bystander coming through the officer alone, I don't think is enough.
You had an officer narrating for the victim. The victim doesn't take the stand. The jury knows that, I take it, or does the jury not know that? Was the jury aware? I'm sure the jury was aware that there was not a complaining witness taking the stand.
Correct. They were aware. I mean, obviously, they saw only 2 people take the stand, and yet we hear
So this
statements.
bystander might have been kind of important.
I agree. I think there were a lot of flaws in the state's case. You have 3 officers responding to the scene. We have 4 or 5 bystanders, a neighbor, and the victim, and all we get is the testimony of 1 officer and partial testimony of a victim. So I think, especially given that this was a domestic abuse case, we're all aware of the difficulty of those cases, the opportunity for victims to recant. I think it could have been handled very differently from the get-go. We also have a 911 call that was not part of our record, but that was made and possibly could have been used. So there were a lot of opportunities the state had to present this case differently so that the confrontation rights were not violated.
Could you address the state's claim that this was not testimonial?
Your Honor, I would disagree with that. I think based on Michigan versus Bryant and Davis versus Washington and Hammond versus Indiana, this clearly was testimonial because we had here where the suspect was identified and neutralized. There were no weapons other than the physical person. There were no guns involved. And it was a statement the purpose of the interrogation was to obtain information about a past event. This was not an ongoing emergency. When the officers arrived, they separated the victim and my client. My client is now in the police car. He's no longer a threat to anyone. And it was also a domestic abuse case, which has a very narrow potential for victims.
How do we draw that line between, the end of the emergency that brings the police to the scene, and then we're on to the purpose of what's going on is to ultimately end up in court? Or how do we do that?
I think one look is that is the threat neutralized? And we do have a neutralized threat here because we have 3 officers responding to the scene who've separated the victim and the defendant, much like in Hammond versus Indiana, when they come to a house, they come upon the wife and husband, they separate them and they ask what happened. And even though the husband is still trying to interfere with that conversation, they keep him separate, and the wife gives a written and verbal statement about what happened. That threat was neutralized. Her statements became testimonial.
Ms. Regenold, can I circle back to maybe a little bit of where we started? Sixth Amendment guarantees a right to confront the witnesses, to question them in court. In this case, your defendant clearly had that right, but for strategic, tactical reasons, didn't want to exercise it. So and Chief Judge Danielson, in his opinion, quotes, I think, from a Colorado case that has a bunch of cases in it that basically make the point where if the person's available, but for tactical reasons you choose not to confront them, then there's no confrontation violation. I didn't see any response to that case law in your briefing. Do you have a response here?
I do, Your Honor. I think, first of all, I think there's been, well, I'll get to that next, but I don't think there was a tactical or strategic reason here. I think what happened was that there was no fact and issue. When the victim took the stand, she only testified to the domestic relationship. That was not disputed. We know that from closing arguments. There was no dispute about domestic relationship or injury because we had the photos of the injuries. The only dispute was whether there was an assault. So it was not a strategic decision. The cases that the Court of Appeals cites to are cases where, for example, I think one is People versus District Court of El Paso County, a Colorado case. And that was where the declarant took the stand but had some memory loss issues, but also the defendant didn't want to test her too much because of potential bias, because the bias was that in a separate case, the defendant had killed her father. Well, they didn't really want to bring that out in a murder case. But the court said, that's a strategic decision. You don't want to bring out that bad evidence. I don't think this is the same kind of strategic decision, because in that case, the declarant did testify regarding her statements. Here, we don't have the declarant testifying regarding her statements. All we have her saying is, he's my boyfriend, we live together, we were living together then. There's no fact and issue. There's nothing to question her about at that time, to cross-examine her about. It would have come later had she testified after the officer.
She was still under subpoena. The Sixth Amendment doesn't say it has to be in the course of cross-examination. It just has to be a right of confrontation. She's still under subpoena, and if the judge had said that's beyond the scope of the direct, you can't cross-examine her on that, which I think is unlikely. The defendant could simply have called her in his case, right?
As I said earlier to Justice Apple's question, I think that turns our system on its head to require us to call the accuser, to bring out the accusation against us, and then refute that accusation. It's the state's burden. And yes, this case was unique in that it would have required the state to try its case a little differently, but it's not our burden to put on the accusation against us.
No, but then you haven't been denied the right. I mean, it's a confrontation right. It's not a right to be confronted within a certain context. It's a right of confrontation at trial.
I agree, but first there has to be an accusation, and then there has to be a witness taking the stand to defend or explain that accusation. That did not take place here because the witness who testified to that accusation wasn't the one who made that accusation. He just reported it. I think what we have here is what the Confrontation Clause was adopted to prevent. We have the ex parte examination. We have the constable or whoever going out to question this witness and then bringing that before the jury instead of that witness themselves bringing it before the jury. And I realize the Turacek part makes this a little more convoluted. But again, had the witnesses been presented in a different order, that could have happened.
Was that an ineffective assistance of counsel by this attorney asking for making a Turacek objection?
I don't think so. I think, counsel tried to keep that out, and I think that's a valid strategy to try to keep that out. But where the strategy problem...
So it's a valid strategy, but then it simply didn't work, because then they were able to get the evidence in through the officer based upon the excited utterance. And again, that's not ever been appealed, correct? That's not subject to the appeal, the court's ruling on the excited utterance,
Correct.
whether,
Correct.
Again, we agree with it or not in retrospect. That's not been subject to this appeal. So she, again, I'm repeating myself, but she got exactly what she wanted, perhaps assuming that you couldn't get this evidence in any other way. You couldn't get it in through the excited utterance or present sense impression or any other exception to the hearsay rules, but unfortunately it did.
My time is almost up. May I respond? I think, Your Honor, counsel's strategy, it was not strategy. Where counsel failed is not thinking one step further. When you're preparing for trial, you're thinking in terms of moves and counter moves. So counsel files this motion in limine to keep that testimony out. So you're thinking, one, how's the state going to respond to that? Two, if I get it, what's going to happen then? The state clearly isn't going to dismiss here. For whatever reason, they're invested in prosecuting this case, and that's their option. But then you have to think, okay, if I win and the court keeps it out under Turacek and she can't testify to it, how are they going to get it in? And if they're going to try to get it in, how do I try to keep it out? Confrontation clause, because if she's not testifying to it, somebody else shouldn't be allowed to, unless we're talking 911 call, possibly, although we have a neighbor here calling instead of the victim, so that adds an extra layer to that. But you need to start, she should have been thinking of all the other ways the state could have been trying to get it in and preparing how to counter that. And that's where counsel rendered ineffective assistance. Thank you.
Thank you as well. Ms. Chambers.
May it please the court? I think the most important thing is to remember that this is in the context, excuse me, of a claim of ineffective assistance of counsel. So, the defense attorney here faced a choice. He raised the Turacek claim, which was successful. But if he had also then raised a confrontation claim, I think the Turacek ruling would have been different. The district court would not have ruled that this evidence could come in no way. So what would have...
How do you say that? I mean, the Turacek, I may mispronounce it, but it strikes me as it was really fairly narrow. The issue was whether this particular witness could testify regarding these events, and the outcome was no. But it had no bearing at all on what a certain police officer could testify to. That was open game. I mean, the prosecution had every reason to believe that it could try and adduce testimony from the officer. I mean, I think their theory of the case was perfectly fine. It didn't violate the motion in limine, I don't think. But at the same token, there wasn't a strategic decision. When the Turacek ruling was made, there wasn't a strategic decision to allow the police officer to testify without objection, right?
I'm not sure if I'm following, but here's what I think. I mean, okay, first of all, we're on direct appeal, so we don't know for sure what counsel was thinking. So if there is a plausible strategic reason for doing what counsel did, then there's
I sure don't see it at all.
Well, okay, so I think perhaps the court's question assumes that these would have been done sequentially. So first I make the Turacek objection, I get a ruling, then I wait till the officer testifies and make the confrontation.
Sure, why not?
Which is, okay, which is not what I was assuming, but even if that is the way it played out, then I think what would have happened is the state would have said, Your Honor, let's go back and look at the Turacek ruling. Couple of things. First of all, I think the Turacek ruling was wrong. We, one, do not have firm evidence that this witness would have taken the stand and denied the assault. She said in her letter seeking to have the no contact order set aside that he did not assault her, but that wasn't under oath. The odds are that if she were asked under oath what happened, she would have told.
And it was totally inconsistent with the version the defendant gave at the scene.
Correct.
But and here's the question. I mean, is there, we don't have a case if there's no confrontation clause violation. And answer me this. How is there a confrontation clause violation? If the motion in limine just applied to the state, which is what I read what the trial judge was ordering, it didn't apply to the defendant. The defendant was free to go in either on cross-examine or calling her in his own case and ask about the incident, then how is there a confrontation clause violation? Why do we even need to worry about ineffective assistance?
The state is very strongly of the belief that there is no confrontation clause violation.
Well, police officers can narrate as long as a witness is sitting in the audience or is at least available for testimony. A police officer can narrate hearsay what the alleged victim would testify to.
It has to be admissible hearsay. So it cannot be otherwise an admissible hearsay, but assuming that would be...
So that's not a confrontation clause problem. Because when I was in private practice, I wanted to testify all the time for clients. And because I could do the narrative much better maybe than a client could. But your position on the confrontation clause, at least, is that police officers can narrate admissible hearsay as long as a witness is available for cross-examination in some context.
That is the state's position.
But that's sort of counter to the Melendez case, because
So I'm sorry, which case?
the Melendez-Diaz case, because the United States Supreme Court, although has not ruled on it, most courts around the country, and I can't find any to the contrary, say that if there's a state law prohibiting somebody from testifying to something, whether it be privilege or Turisek or anything else, they're unavailable. And I don't know what the U.S. Supreme Court will do, but that's been the rulings around the country. So let's say that's right. Melendez says that the confrontation clause imposes a burden on the prosecution to present the witnesses. When you follow the Melendez, when you follow that note in the Melendez clause, federal courts and state courts around the country say that, and this is a state thing, it says, testimony from the child before admitting the child's hearsay puts the defendant in a constitutionally impermissible catch-22 position of calling the child for direct or waiving his confrontation rights. And how do you get around that argument if Melendez is right that the state has first the burden to put the stuff in the evidence? And courts all around the country have gone off that, calling this a catch-22.
You get around that by the fact that the only reason the victim didn't testify about the acts herself was because the defendant filed a motion in limine to keep her from doing so. The state filed...
let me interrupt you, I'm sorry, but what if the defendant filed a motion in limine if it was his spouse, and there was a good spousal immunity, and domestic abuse there isn't, but if there's a good spousal immunity, I don't want her to testify to that, about my criminal activity. So can the police officer testify to it if she was upset at the time and told him? I mean, he has a right to keep that statement out under state law, which is what all these cases say. And what you're doing is you're turning Melendez on its head by saying that the defendant does not, that the defendant has to put on the bad information and effectually waive his confrontation rights, whereas Melendez is pretty clear the state has to do it, and that's my problem.
Okay. We are not saying that the defendant has to waive his confrontation rights. We are saying that the defendant can't rely on Turisek if he wants to exercise his confrontation rights. That witness testified, and it was the state's intention to have her testify about the acts of the crime. The minutes of testimony for her reflect that. The only reason the prosecutor didn't ask the witness what happened was because the defendant's motion in limine kept that out.
But isn't your problem with Turisek not really, you'd say Turisek shouldn't apply in a case because now we have this confrontation clause. I mean, aren't you really saying we shouldn't have Turisek because clearly it's a privilege or a tool that the defendant can use to make the person unavailable, and it's recognized. And to say that the judge would rule otherwise, you really want to modify Turisek saying that if there's a confrontation clause problem, then Turisek shouldn't apply. And I don't see how you get that, and I don't see how it's argued that way.
Okay, there were a few questions in there, so I'll start with what I think is the last one. I did not argue that Turisek should be overruled or modified. I think it should be. I think as it's applied, courts apply it very broadly. Both prosecutors and defense attorneys interpret it very broadly. Everyone's really afraid of Turisek. And so lots of things, in this case as an example, don't come in that should have come in under the strict holding of Turisek. So yes, the state believes that Turisek should be overruled. The state did not ask for that in this case because this comes to the court in an ineffective assistance of counsel context. And it's the state's strong belief that there is neither testimony nor a failure to confront here. The witness testified. The defendant chose not to ask her about what happened. The state wanted to ask, but was precluded. But even if the state had not wanted to ask, even if there hadn't been the motion in limine, the witness was there, the defendant could have asked. He didn't ask, and so he cannot complain about the lack of confrontation. For strategic reasons, he chose not to ask, probably because he was rightly afraid that when on the stand, under oath, the victim would tell what really happened.
I think that's all fine, but the question is, can the police officer narrate and take the affirmative role of introducing this testimony, admittedly hearsay, does that violate, I mean, does confrontation, I guess, mean more than allowing a witness to narrate on behalf of a second witness and then calling them for potential cross-examination?
If the victim hadn't testified, and if her statements to the officer were testimonial, a point the state strongly contests, but assuming that it was testimony and the victim did not testify, no, that testimony could not have come in under the confrontation clause. But that is not the case we have here. It's not testimonial. If you look at the U.S. Supreme Court's decision in Bryant, and you look at the multitude of lower court decisions on that point, almost all of them hold that the initial comments to the first responder are not testimonial.
Do those cases involve where the defendant has already been put in the back of the squad car, the threat neutralized, so to speak?
It's not possible to tell in some of those cases, but frankly, almost never is the victim going to be talking to the officer until the threat has in some form been neutralized. I mean, you might have some shouted, "Oh my God, he's stabbing me," kinds of comments, but for the most part, any statements that the state is bringing in mostly are going to happen after there's at least been some form of neutralization.
How do you distinguish this from Hammonds, though?
Pardon me?
How do you distinguish them from the facts of Hammonds?
In Hammonds, the only similarities really are that it was a domestic abuse case. When the officer arrived there, the victim was sitting alone on the porch. Everything was quiet. She told the officer there was nothing wrong. The defendant was inside in the kitchen, and the officer was able to have a calm conversation with the victim, sought permission to enter. She granted it, and then he went in and talked to the defendant. In this case, let me just say first, because no confrontation clause was raised here, the facts surrounding the testimonial issue are not fully developed. But on the facts that we have, the officer arrived, the two were still shouting and yelling, and one of them is bleeding. It took the officer like 15 minutes to get the defendant calmed down enough to get in the car. Even then, he's yelling across at the victim. And the officer simply said, we don't know the exact language, but he testified at trial that I just asked what was going on.
Hammonds turned on the emergency was over because the victim was separated, not that it was a time frame. And in this case, the victim, the perpetrator, was in the car, so, quote, the emergency was over, as they contrasted to Davis in that case, where the emergency was still ongoing.
But I think the more pertinent contrast is with Bryant, where the officer arrived after a 911 call by someone else. It was at a different location than the shooting. It was about 25 minutes later, as it was here, by the time the officer questioned the victim. There was clearly no immediate attack going on, and yet the U.S. Supreme Court found that this was not testimonial. There are cases, of course, where the officer responds, the initial "what's going on" question is answered, and then the conversation continues, and it can at some point become testimonial. But here, the officer simply asked one question to figure out what was going on. Again, we don't have a full record here, but there were at least some allegations that there was a girlfriend involved, and the defendant was claiming that his own girlfriend was having an affair with another woman. We don't know, and again, we look at the time of the offense, not what we know now. We don't know if the officer knew if there was another person still there. There may have been another victim inside.
I've got a question, I guess, and just because I think your time's going to run out here pretty quick. We have a special concurrence here by Judge Pottersfield here. Do you really think the record is developed enough in this case and on this record that we can actually rule on this ineffective assistance of counsel, or shouldn't we take the approach that we need to have what the attorney was thinking about here and whether there was any type of trial strategy, what was going on here? I think opposing counsel indicated that you got to be thinking all the way down the line. Maybe this person was or wasn't. Do we need to give that person the benefit of the doubt and preserve this for post-conviction and a full development of the record on this?
We certainly have to give counsel the benefit of the doubt. I think the record is sufficient to decide it on the ground of lack of prejudice. There probably was a tactical reason, and even if there wasn't, any confrontation clause, any objection to the confrontation clause would have been denied. So if the court agrees with the state that the confrontation clause would have been a confrontation clause objection would have been unsuccessful, then the court can rule on direct appeal and reject the ineffective assistance of counsel claim.
What do you make of the bystander, the bystander statements that came in and confrontation? You don't have the Turasek problem there.
We don't, and if the state had attempted to offer that statement through the officer, I think we would have had we do have a confrontation clause issue. It would be harmless though, because as it is in this case, because it was a volunteered statement. The state's approach to the bystander statement was, we didn't pay any attention to it. We didn't present it to you. We don't think that witness is reliable. So under those circumstances, there's no prejudice. But I think if the state had elicited that comment on purpose, and had there been a confrontation clause objection, it should have been granted.
Well, but help me a little more with it, 'cause the jury knew that the victim did not take the stand. And
The victim did take the stand, Your Honor.
Did not testify about the events. You're right, of course. And that might have raised some concerns in the jury. And then you have this bystander comment come in. Maybe it's more important than it seems. How long was the jury out too, by the way? Do you know?
We don't know.
Okay. But you see the argument that on the one hand, you're
Or I
saying
don't
it's just
know.
a bystander, and but on the other hand, if it's a contested case and we don't have the direct testimony from the victim, can we really say it's harmless error?
I think we can, Your Honor. Again, if counsel, would it have changed the outcome of the trial? Because this is an effective assistance of counsel. It would not have. The jury certainly was aware that the victim didn't testify about the circumstances of the crime. That no doubt worked in the favor of the defense. The officer testified, and the officer himself considered that witness unreliable. I think it's not reasonable to believe that would have changed the outcome of the case. Is there no further questions?
Thank you, counsel. Rebuttal, Ms. Regenold?
Thank you. Despite the state claiming that it didn't rely on the bystander statements, in its rebuttal argument, the state certainly did. We have on page 109 of the appendix, we have the state saying, let's see, her telling police that he did it. You have another person who says he did this. Whether the victim came in and said what happened here at the trial is irrelevant. Don't get hung up on that. It is irrelevant as to whether the defendant is guilty or not. Whether we call additional witnesses or not are irrelevant. If what they know comes in already in another way, we don't need to then call additional witnesses. That's not reasonable doubt. To hear someone say, yep, she came over and told me to call the police because her boyfriend assaulted her, the exact same thing that you already heard doesn't add anything to the case. It's called irrelevant. It's not going to assist you in deciding the case. As I said before, the state fully got the benefit in this case of being able to call all of these, get the testimony or the statements of 4 witnesses through one individual. And I also want to talk about one other concern I have about the Court of Appeals decision is it cites to U.S. versus Owens. And I think it's somewhat erroneous in its reading of Owens, as many other courts have been in their reading, in that Owens was both about confrontation and about hearsay. And we know that while there may be some overlap, they are certainly 2 different things. And it's in its analysis that it conflates those 2 things, as I said, many courts have done. And I think that there's some concern there that just because the language relied on is from the hearsay part of Owens, and it says that for a witness to be subject to cross-examination, he just has to be placed on the stand under oath and respond willingly to questions. And as one scholar commented, that may be the rough dimensions of what is required, but you also need an accusation and the reliability of that accusation to be tested. And the reliability of the accusation was not tested here because it came through the officer. And once again, you cannot test that because you're testing his memory of the conversation. You're not testing the person who participated in the alleged assault and their memory or recall or bias, whatever it might be.
Counsel, is it true that the motion in limine applied only to the state?
That is not completely clear to me. My understanding from the record is that it could have applied to both parties. I know certainly the concurrence in the Court of Appeals decision felt that there was some concerns about what may have taken place off the record regarding that issue, that there may have been some restriction on cross-examination by the defense. So I think it could be read that there was some limitation on the cross-examination so that the defendant could not have cross-examined her regarding this because it had already sought to exclude that testimony.
Couldn't the defendant have withdrawn its motion in limine or varied it? In other words, wouldn't the trial court have had discretion to permit cross-examination if the defendant wanted to question the victim about her statements?
I think as the way the case was presented, no, because that would have been beyond the scope of the direct examination, and that fact was not in issue yet. It did not come into issue, as far as the accusation about the assault, did not come into issue until Officer Jurgensen testified.
Now, my trial experience in civil cases, at least, I never got far with an objection on my cross-examination, or an objection that was beyond the scope. The judge would, in his or her discretion, permit that line to spare the trouble of simply bringing the witness back. Didn't the trial court have discretion to permit that?
There is a permissive passage of the rule that says for a good cause. I don't think that existed at the time the victim took the stand in this case because, again, that fact was not an issue. All she testified is there was a domestic relationship.
But you recall her. You recall her and you say that you need to cross-examine under Crawford, or cross-examination, you need to cross-examine under the Confrontation Clause, and if that rule is enforced, you got a constitutional violation. District Court, oh, let's hear the evidence. I mean, isn't that a plausible scenario?
I'm sorry, I got lost in that, Your Honor. Could you?
It's a poor question, I'm sure. But if you had called the victim and...
So if the defendant had called the victim
right.
himself.
And then the objection was outside the scope, and then you say, well, I have a constitutional right to cross-examine. Isn't the district court going to likely say, okay, go ahead and cross-examine, notwithstanding the rule?
At that point, and the accusation has not come in, is that what you're saying?
Well, it's come in through the police officer, and now you're
Oh, yes, absolutely. I think at that point, yes. I'm saying the way if I may finish, Your Honor, I think that the way it played out in our record, I don't think he could have gone beyond the scope. But had it been different, that the officer testified first and the accusation came out, then the victim testified to the domestic relationship, yes, it would be beyond the scope, but I think for good cause, the court would have allowed it.
Chief, could I ask a follow-up question specifically? Your position as to Judge Potterfield's special concurrence, is the record adequate, or should it be sent back or preserved for PCR?
I think as to the issue of whether there was a limitation on the cross-examination, not to the issues that I raised, but that specific part of the issue, because she references some discussions off the record, possible negotiations. We obviously are not party to those, and on that particular issue, I think that part would have to be preserved, Your Honor. Thank you. We would ask the court to reverse and remand for new trial.
Thank you as well. State versus Tompkins then is now submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.